Well, good afternoon and welcome everyone to today's Southern Fire Exchange webinar. My name is David Godwin and I am the director of the Southern Fire Exchange with the University of Florida. I'm hosting the webinar today from Tall Timbers Research Station north of Tallahassee, Florida. Today I'm excited about our presentation from Dr. Carissa Wonkka from the University of Nebraska. Dr. Wonkka will be talking about her work investigating how the landscape of laws and regulations impact prescribed fire in the U.S. So now it's my pleasure to introduce our speaker today. Dr. Wonkka received her BS from the University of Massachusetts and her MS and PhD from Texas A&M University. She also obtained a JD from Suffolk Law School with a focus on land use and environmental law. She's currently working as a Postdoctoral Research Associate at the University of Nebraska and is starting a position as a research ecologist with the Northern Plains Agricultural Research Laboratory, USDA ARS, in Sidney, Montana this spring. Her research focuses on understanding the intersection of law and ecology and complex social ecological systems and developing effective ecosystem management strategies for human-altered landscapes. Her current projects include 2 Joint Fire Science Program funded projects. One is aimed at understanding the social and regulatory barriers to the use of prescribed fire by private landowners and managers in the southern Great Plains. The other focuses on tying fire behavior and plant physiology to experimental restoration of resprouting shrubs in the rangelands. So welcome, Carissa. Thank you all for joining us today. I'm looking forward to your presentation. One moment as we trade out the slides.
Okay. Hi, thank you everyone for participating in the webinar, and thank you David and the Southern Fire Exchange for inviting me. I'm very excited to talk to you guys today about a lot of the research I've been doing over the duration of my career on statutory and regulatory and legal constraints on prescribed fire in the US. So I guess it's probably no surprise to anyone listening, but just to talk a little bit about the implications of some of this work, we've had a long history of fire suppression as management policy in the United States. And this has led to a lot of issues with fuel increases and led to some of the wildfire issues that we have today. I think a real shift in this thinking occurred around the '88 Yellowstone fires, and federal policy at least started to shift toward an understanding of the ecological importance of fire for many of our fire-dependent ecosystems. And this has really worked its way into the federal wildfire policy strategies and a lot of the federal level understanding of how we should implement prescribed fire on the landscape. So this is the National Cohesive Strategy. The National Cohesive Wildland Fire Management Strategy is a strategic push to work collaboratively among stakeholders and across landscapes. So their aim is to use best science to make meaningful progress toward 3 goals. Their first goal is resilient landscapes. The second goal is fire adapted communities. And then the third goal is safe and effective wildfire response. And I think it's really important to note that their vision is to safely and effectively extinguish fire when needed, but also to use fire where allowable to manage our natural resources and to live with wildland fire. So I think it's an important shift in strategy from an idea that all fires need to be suppressed to an understanding that we can't suppress all fires. And a lot of ecosystems are fire dependent, and the more we try to control them without implementing fire, the less control we really have. However, this shift hasn't necessarily trickled down to private land prescribed fire in all parts of the country. So private burning is really important. Our country is comprised of a huge amount of private lands, and without prescribed burning on private lands to limit fuels, we really aren't going to reach the goals that we need to do fuel limitation and effective ecosystem management nationwide. So trying to figure out ways to get private burners in different states interested in taking part in this use of fire to limit our fuels and to increase our capacity to provide ecosystem services is really important. So in the states, we have different statutes that regulate prescribed burning, and they differ a lot among states. We have a general history in the United States, and this has trickled down into state statutes as well, due to European influence with suppression. And so we see a lot in older fire statutes and burning statutes, and then in the common law, which is judge-made law in different states where we would see prescribed fire coming into the courts. And this history has focused a lot on something called strict liability, which listed fire as a very difficult thing to control, and therefore anyone lighting a fire anywhere would be responsible for any damages incurred from that fire, regardless of the circumstances surrounding it. So that was our history. And that came out of this history of wildfire suppression in the United States. We also had a lot of open burning bans in the United States historically in this era of suppression, where you would have counties having the capacity to shut down all burning. And then also we saw common law for civil liability is our European heritage. So most states started out as common law civil liability states. And what that means is precedent from previous court cases ruled what happened in cases of torts, which are personal property damages and personal injury damages of one person suing another person. So we have that liability background where strict liability applied to fire at first, and then civil liability was regulated by common law. But we've seen a shift in that recently, where we have a lot of statutes being promulgated that relate to prescribed fire. And I think in part this is because people are understanding that we need to have more private land prescribed burning, and these old types of statutes and these old understandings of liability were really not conducive to promoting prescribed fire use on private lands, and we're really hindering people from being able to feel comfortable in lighting fires on their land. So just to give you an idea of what some of the older statutes might have looked like, Nebraska has an open burning statute, and this has been on the books for quite a while, and it implies a statewide open burning ban on all fires, and it includes, you'll see in the underlined portion, fires for the purpose of clearing land. So this means that the state of Nebraska has a lot of control over who can burn and when. So the fire chief of any local fire department can allow someone to burn, but they don't have that right. The right is for the fire chief to say, okay, there's this ban, but we'll let you burn. And so it really becomes the situation where you have to have a good relationship with your fire chiefs, and fire chiefs have to understand the importance of burning, and it becomes very much discretionary for the fire chief, and there is no right that's inherent in the landowner to burn his own land. So you'll note the end of this paragraph here that says the fire chief can waive the burn ban when conditions are acceptable to the chief. So again, it's very discretionary on the part of the fire chief, and it varies a lot as to whether people will get to burn dependent on who their fire chief is. And that's not really a great law for promoting prescribed fire, because you have to really build that relationship with your fire chief, and some are just completely unwilling to burn, others are very open to it, but it doesn't provide a lot of security for prescribed burners going into prescribed burning, that they'll feel confident that they can get their goals accomplished. And so a lot of states have been enacting these right to burn acts, which is a statutory reform that started there in the Southeast. And so it's the right to burn acts makes prescribed fire the right of the landowner. And that's very important because it makes it much more difficult than, for instance, the case we saw in Nebraska, to restrict burning. A fire chief can't restrict burning just because he feels like it, because the right to burn lies in the landowner. So also, many right to burn acts specifically state the level of liability that will apply to instances of escaped prescribed fire and damages resulting therein. And that's really important because it clearly sets out for the landowner what their liability is. It's important for them to know that. In a lot of states where we don't have right to burn acts, the level of liability is really uncertain and depends on the judge in the particular court that you end up in when you are someone pursues a case against an escaped prescribed fire defendant. In addition, it establishes certified prescribed burner programs and what the requirements will be for setting those up. Most of the Right to Burn Acts set guidelines for how to create a board which will oversee the certified prescribed burn management programs and lists some minimum requirements for becoming certified, but really leaves it up to the group that they've designated to be in charge of that program to establish the things that will be required in order to become certified in the state. So it creates a little leniency for a group to shift their ideas about what they think is necessary for training and additional requirements for certified prescribed burn managers as their understanding of things on the ground evolve. The Right to Burn Acts also lists some regulatory requirements that are necessary in order to gain some of the limited liability that they can provide for people. So for instance, in Florida, there is a gross negligence standard rather than a simple negligence standard. And I'll talk a little bit more on the next slide about what those differences are. But it's a limit in liability to shift from simple to gross negligence. And so the certified prescribed burn managers are allowed to have that limited liability if they adhere to a certain set of regulatory requirements. And those are different across all of the states, and they're set out in the Right to Burn Acts. And it usually lists them very clearly in there. And then there's also some information on burn ban exemptions. And so I'm not sure how often burn bans are actually put in place in the Southeast, but in the Great Plains, we have a lot of burn bans. And that can really limit the amount of time that people can burn. And so even in states where we have statutory reform and we have more understanding of landowners' right to burn, we still are seeing some of these burn bans being put in place. For instance, in Texas, burn bans can be established by county commissioners. They're based on weather conditions, fuel conditions, drought, and other things. And there's usually a program that they can use that works with the Forest Service to establish when a burn ban will be put in place. But we've also seen that some county commissioners are very risk adverse and they'll put burn bans in place a lot more frequently than others. Others are very open to burning under many different conditions. And so they'll have burn bans at any different time. So these statutory Right to Burn Acts can have information in there about when burn bans are to be established and when they are not to be established. And so that can really help make it clear that a county commissioner, for instance, or a Forest Service entity can't put a burn ban in place unless certain conditions are met with regards to fire danger. Now, there are some ways around these burn ban exemptions other than the Right to Burn Acts, and I'll talk a little bit about that later. But in the Right to Burn Acts, they can put language in there to limit the amount of burn bans that are established or provide exemptions for certified prescribed burn managers. And so Georgia and Florida are two of the first states to have moved toward limiting liability for certified prescribed burners. And the purpose of doing so is to encourage prescribed burning for resource protection, public safety, and land management. So this move towards gross negligence with some regulations will really allow the landowner to feel a little more safe in being able to burn, that he will only be held liable under certain conditions. And a lot of states have followed suit that have established Right to Burn Act, doing a limited liability for certified prescribed burners as well. Just just a note on certified prescribed burn management programs. Megan Matanis from the Intermountain West Regional Manager for the Forest Stewards Guild sent me this really nice report, and I have the link to the report online. And she developed this report as guidance to the state of Washington in developing their certified prescribed burn manager program, but it has a really nice summary of all of the different certified prescribed burn manager programs in the country and what different ones look like. So they provide training for burn managers in the state, as I discussed in the previous slide. They're implemented by different agencies, and this is set forth in the prescribed burning law. 15 states currently have active and formal programs for certified prescribed burn managers, and 4 states are currently developing programs. And so I think sometimes when I talk to people that don't have certified prescribed burn manager programs, they become concerned that this could be the state attempting to regulate prescribed burning. It's true for a lot of the states in the plains where I've talked to burn managers who don't currently have burn programs. But I think it's some important piece of the puzzle that's left out of that consideration is that all of these right to burn acts still allow for prescribed burning and place the right to do prescribed burning in the hands of the individual doing the burning. And whether that burning becomes certified or not is up to that individual. Becoming certified usually comes with a lot of incentives like limited liability and getting to burn during burn bans or that sort of thing. So it's not in any way limiting any landowner from doing prescribed fire, but it is providing a training program to increase safety for prescribed burners in the states where they're implemented and give them a little bit of incentive to do prescribed burning in a safe and controlled way. So I think that if you talk to folks that don't have certified prescribed burn manager programs, I think it's important to focus on that fact that these are not going to limit landowners who want to burn and don't want to be certified. They just offer incentives for those who do. So just to look at some of these right to burn laws, again, Florida was the first state to implement a right to burn law. And it's really important because it sets out statutory language that speaks to legislative intent. So we see here that the application of prescribed burning is a land management tool that benefits the safety, the public, and the environment of the state. That's really important because anything that comes down the pipes later legislatively needs to look back at this legislative intent in order to recognize that this was something that the state deemed important, and this is a value that the state has ruled on. And so having this language in here that shows that the intent of the legislation in developing this act was to increase prescribed burning on the land because they see it as essential to the management of animal communities and the reduction of fuels. I think that really speaks to the state's feelings about prescribed fire. And so when you see other potentially contentious legislation coming down the pipeline that could limit the right to burn in any way, that having these right to burn legislative intent sections in the statute really helps establish what the importance of these statutes were to the state at the time they were developed, and keeps people with an understanding that this is an important thing to have done. So I think when we talk about right to burn acts, we tend to get bogged down in a lot of the regulations and the CPBMs and the liability limitation, but it's important to note that just having language in your statute that says prescribed fire is essential to the ecosystems in your state is a really good tool for maintaining the prescribed burning in the state and the right to prescribed burn in the state. Georgia's act came shortly after Florida's, and it's very similar in language. You can see that they list why prescribed burning is important, that it reduces hazardous fuels, prepares sites for forest regenerations, improve wildlife habitat, controls insects and disease, perpetuates fire-dependent ecosystems. So having that in there really sets apart why it's important to allow prescribed burning in the state. And they explicitly state that pressures from liability issues are important to Georgia, and they are really reducing the amount of prescribed burning in the state. And therefore, this act seeks to limit that liabilities and so promote prescribed burning in the state. And that's a really important statement to have in there because, again, any additions to the Prescribed Burning Act or any laws that contradict the act later will have to show that this really important understanding has changed in the state. And so just to talk a little bit more about legislative intent, this is from a court case that happened in Florida. And you can see in the underlined language that the judge really kind of harped on this legislative intent, that when he read the statute that he was being asked to apply to this case, then he saw that Congress, when creating the legislation, when creating the statute, really had this purpose in mind, and to address this case in any way that undermined the gross negligence for this prescribed burner would be contrary to legislative intent. And so that becomes important not only for future laws, but also in how the judges are going to apply these laws, because that can be pretty different from place to place and judge to judge. But if the statute has this language in there that talks about how important prescribed fire is to the state, then the judge will most often deem to see the statute as it was meant to be set out. So I talked about legislative intent. I talked about certified prescribed burn management programs. One of the most important things to me that the Right to Burn Acts can do is to limit legal liability. And we see a lot of times when prescribed burners are doing surveys or talking to people, they list legal liability as one of their biggest potential factors for not doing a prescribed fire. We did a survey in Texas and Oklahoma of prescribed burners, and survey respondents who perceived a higher level of fire-related legal liability were 25% less likely to apply prescribed burns on their own land and 38% less likely to assist with the application of prescribed burns on someone else's land. Additionally, burn bans, which the ones that restrict the use of prescribed fires during hot, dry periods, were significant barriers to respondents' willingness to burn on their own property. 43% of respondents agreed with the statement that we posed to them, which said, "I have been prevented from using prescribed fire due to burn bans imposed by county commissioners." In Texas, they kind of overcame that a little bit because a lot of landowners went to their legislators and asked for a law to be on the books that would allow for them to burn during burn bans if they were certified prescribed burn managers. So a lot of certified prescribed burn managers in Texas aren't hindered by the burn bans. However, we still saw that 43% of our respondents said that they have been prevented by burn bans. So this is a big issue for a lot of prescribed burners. And liability seems to be one of the #1 reasons why people don't want to burn on their land. So given that, we undertook a study to look at the different liability standards across the United States and how they might affect the amount of prescribed burning that's done in the different states. So the different civil liability standards are gross negligence, strict liability, simple negligence, and then undefined is a place where you don't have a statute and usually simple negligence will apply. So under strict liability, a burner is liable for any damage caused by an escaped prescribed fire, regardless of the action of the burner. Under simple negligence, the burner has to practice reasonable care in applying prescribed burn, and that's the level of care that someone else in that situation would apply. And then under gross negligence, if a burner follows regulations regarding burning, the plaintiff in a case against him must show wanton and reckless disregard of the duty of care owed to others by the burner. And that's really a much higher standard. So he can be a little bit careless in the burn and will still not be liable. He will only be liable if he or she shows wanton and reckless disregard. And that's a much higher standard. And that is increasingly becoming popular in states that are enacting right to burn acts. So at the time that we did our study, only Florida, Georgia, Michigan, and Nevada had gross negligence liability statutes. And now Washington and Colorado have enacted gross negligence as liability standards for certified prescribed burn managers. Just a few notes on some of these states. Michigan has a gross negligence standards for damages only if the fire does not escape the boundary of the area authorized in the permit. So if something burns up in the boundary of your prescribed fire that you are doing, then gross negligence is applied. But if the fire escapes, then a simple negligence standard is applied. So it's not as true of a simple or gross negligence standard as Florida and Colorado and Washington and Georgia have. And then in Nevada, while they do have a gross negligence standard, it mostly applies to government agencies because prescribed burning is not done by private land managers in Nevada. And if it is, it's usually overseen by a government agency that is allowed to do fire. So the gross negligence standard there isn't as true of one for private land burners as it is in the other states as well. I think partly because of fear from the Little Vale escaped fire in 2016. So one of the big reasons why they don't allow a lot of private land burning. And then also the sage grouse and cheatgrass issues there prevent a lot of burning because fire is seen as incompatible in that landscape, and they don't see a need for more prescribed burning because they've seen increases in the frequency of prescribed fire since cheatgrass invasion. And then in Wisconsin's Prescribed Fire Council is looking to promote a prescribed burn act right now. They are establishing right to burn legislation, working with senators to bring it to the floor. And their right to burn act would establish a certified prescribed burn management program and then limit liability as well. Oh, and I also should mention South Carolina has gross negligence for smoke and simple negligence for fire. So if an accident is caused by smoke and there's personal injury or property damage, that burner will be liable to gross negligence. But if the accident or the damage is caused by fire directly, they will have simple negligence standard applied to their case. So basically, gross negligence is an incentive to try and promote burning in the state. And so in a lot of times when you have gross negligence limited liability, that'll apply only to certified burners, and other burners in the state will be subject to simple liability. And this is an incentive not only to prescribe burn more often, but also to get training and become certified so that you're eligible for this lower liability. And this shifts the burden of liability away from the burner and onto the neighbors to some extent. So whether this is a good thing or not is questionable, but when you are trying to accomplish a lot of the goals that these acts are trying to accomplish, like limiting fuels and promoting ecosystem services, I think that the right to burn acts recognize these are important enough that we should shift that liability away from burners to promote prescribed burning. And so how are judges actually applying this standard? That's one of the biggest concerns, I think, in states that are shifting toward gross negligence, is are judges going to actually see the importance of adhering to the gross negligence standard? And we've seen from Georgia and some other cases from Florida and Colorado as well, that judges are applying these gross negligence standards as they are defined by the statute. So in this case of Wolf v. Carter, we saw that the judge came down on the side of the defendant and said that gross negligence, as it's been defined in the state, which is the failure to exercise even a slight degree of care or the lack of diligence that even a careless man is accustomed to exercise, meant that there was no evidence from which a jury could reasonably conclude that Carter failed to exercise even a slight care. So the jury initially found the defendant, who was the prescribed burner, guilty for the damages, and the appellate court overturned that, saying that as gross negligence applied, there wasn't enough evidence to say that he was grossly negligent. And the judge also added some language in there to support this opinion. And he said that it was undisputed by the parties that Carter conducted test burns before starting the controlled burn to ensure smoke would not blow across the highway. This was a smoke-induced accident. And also that he remained on the premises until no flames were visible and only light smoke remained. Accidents on the highway resulted from smoke crossing the highway after the prescribed burn was over, and Carter did everything he could to avoid it. And so basically, it was a very high standard that the plaintiff was going to have to meet here to prove that Carter was grossly negligent, and all the evidence supported that he hadn't been so. So these judges are applying gross negligence standards at a higher level of liability or duty of care than the simple negligence standards. And so I talked about these additional regulatory requirements as well. This was something that we wanted to look at in our study because we weren't sure if an additional regulatory burden might be a disincentive to burning, especially if they're unclear or stated poorly. So this also might depend on characteristics of the state involved and then language in the Prescribed Burn Act. But for the most part, when they have regulatory requirements for attaining lower liability, it will include getting a burn permit, sometimes having a certified prescribed burn manager on site, having a written burn plan, and then some states such as Florida require adequate personnel and fire breaks. And then also we looked at burn ban exemptions to see if burn ban exemptions would increase the amount of prescribed burning on the land. And so our study area was Georgia, Alabama, South Carolina, and Florida. And we chose this area because records have been really well kept on the amount of prescribed burning going on in these states. So as a part of submitting a prescribed burn plan and getting a permit, these states are keeping records of the amount of prescribed burns they're permitting. There aren't a lot of great data on the number of private land prescribed burns being done in other parts of the country. And so it was really great to see that. And I really thank all of the Forest Service entities that helped me collect or gave all these data to me so that I could do this analysis. And so we focused here because of the quality of the data that were here. And then also, we really wanted to use counties sharing state borders instead of the whole state, because there are a lot of differences across a state in things that might influence burning other than laws, such as topography, fuel types, weather. And so if we just looked across the whole state, we weren't really getting a side-by-side comparison of the differences. Here, where we're looking across a geographic boundary, which is the state line, we're going to be very close. So we have similar weather, similar topography, other types of things that would affect fire behavior, all of that very similar. And the only difference is in the statute that's in play in the different states. So for instance, Alabama has simple negligence and Georgia has gross negligence. So we were able to compare the counties directly on the Alabama-Georgia border and then also on the Alabama-Florida border because Florida has gross negligence. And then similarly, South Carolina, which had simple negligence for both smoke and fire at the time, and Georgia were directly comparable across the boundary. So again, we wanted to match up counties that were very similar in all variables except their level of liability in our analysis. And so what we saw was that gross negligence counties burn an average of 4% more acres than simple negligence counties right across the border of them. That's almost 3 times more fires. There was no difference in the number of burns or land area burned between states that only required permits and those that had additional regulatory requirements. like CPBM on site or burn plan present, etc. So we weren't seeing these regulatory requirements as being overly burdensome and reducing the amount of prescribed fire on the land. And then in the states that allowed for exemptions for certified prescribed burn managers, that didn't lead to any greater land area being burned. But this could be because of the study area chosen. So again, we've probably seen in Texas that this is really important for people and would see more fires being burned where those burn ban exemptions were allowed, because we have a lot of burn bans put in place in Texas, but that might not be the case in those states. We didn't see a lot of instances of burn bans shutting down prescribed burning during the time frame that our study was conducted in Florida, Georgia, South Carolina, or Alabama. And so just to give you an idea of what this looked like from year to year, we had gross negligence burning increasing the percent of the land area burned over simple negligence in every year of the study. And all of these data are in my ecological applications paper in 2015, if you want to take a look at them more closely. So states with gross negligence liability standards have more private landowner use of prescribed fire and increased amount of land area burned compared with simple negligence states. So we are seeing this limit in liability translate to increases in prescribed burning. Regulatory requirements aren't having a large effect on the amount of burning. And so what this translates into for our study area is a 2% increase in burned area for counties with gross negligence compared to simple negligence means that in Alabama alone, our study area included 7 million acres, and we saw 147,000 acres more burned just in our border counties alone. So you can imagine how that could translate to quite an increase in acres burned for the different states. So I just want to talk a little bit about kind of this transition in looking at our traditional laws versus moving to things like the Right to Burn Acts. So traditional administrative laws, they're performance-based regulations. Essentially, they've been created between regulators and unregulated parties. So with this very distinct divide between the people who are creating the laws and the people who are required to follow the laws. And the latter, the regulated parties, will play a really passive role under traditional administrative law. So this idea about management best practices and prescribed burning has really encouraged the regulated parties to play a more proactive and innovative role. It's allowed other stakeholders in prescribed burning to have easier access and participation in the policymaking process. And so what I mean when I'm talking about this management best practices is this proliferation of prescribed fire councils and coalitions across the United States. So in the US, we have had a rapid uptick in the number of prescribed fire councils and coalitions. And a key mission of these councils has been to partner all entities with vested interests in prescribed fire and to encourage exchange of information among them. These entities often include government agencies, landowners, fire professionals, nonprofit environmental organizations, academia, individual citizens. During our study, we looked at the number of prescribed fire councils in the United States, and it went from 0 to 25 between 1990 and 2011. And there are even more states with prescribed fire councils today, and still some developing prescribed fire councils. Most states that do any amount of prescribed burning currently will have a prescribed fire council. And these can really help develop these right to burn acts. And they're usually very much at the center of developing legislation and trying to help landowners bring it to a senator and bring it to their state legislation. So management-based regulations really encourage more participation in the policy process, and that can really help create the type of burn act that a state needs in order to promote prescribed fire within that state. So to switch gears a little bit, some of the other research I've been involved with lately, out beyond prescribed fire liability, is to do a review of all of the laws and regulations that might limit prescribed burning. So open burning ordinances are big at play in the state, but they're not the only laws that limit prescribed fire. There are many legal bases for regulating prescribed fire, and most of them result in limiting the conditions under which prescribed fires can be conducted. So general tort law is what we just talked about, where personal injury and property damage is governed by a state liability standard. In the states that don't have right to burn acts, there can also be criminal nuisance laws, and those largely apply to smoke drift into communities, but can also apply to escaped prescribed fires, where fire can be deemed a nuisance and someone can have criminal action taken against them for escaped prescribed fire or poorly managed smoke. There's also forest fire control laws. These are best management practices. This interacts a little bit with liability, whereas people become more open to liability if they're not following forest fire control laws. And these can restrict the conditions for burning. Most of the time, they establish wind speeds or relative humidity levels that are, or temperatures that are okay for burning and those that aren't. And a lot of this applies mostly to agencies that are doing burning and not to private citizens. But again, a lot of Western states have vast public lands, and so these fire control laws can limit the amount of prescribed burning done in those public lands if they're limited to doing burning under certain conditions. And then another big one for a lot of states is air quality laws, where states implement plans under the Clean Air Act to focus on control of particulate matter. I know that the Southern Fire Exchange just did a webinar on that a little bit ago, so I'm not going to focus on that a lot, although it's definitely one of the bigger limitations for a lot of states, especially Western states. But I will give a few examples in the slides coming up about how that can affect prescribed burning. And then we also have national environmental laws that can affect the amount of prescribed burning that goes on. Endangered Species Act is a big one. Incidental take during fire is against the federal law of the Endangered Species Act. So a lot of times when agencies are proposing to do prescribed fire on federal land, they will have to do an environmental assessment. If they find endangered species on their land, they have to show why the fire will not cause incidental take. So a lot of times fire will be shut down because there's an endangered species. And then also the Clean Water Act. Best management practices for erosion and sedimentation need to be in place. So in burning in different watersheds, there needs to be some consideration among agencies doing burning that would show that water will not be impacted by sedimentation. The Migratory Bird Treaty Act is one. Its enforcement's pretty spotty from state to state, but the Migratory Bird Treaty Act requires that federal cost share users not have incidental take of birds and bird nesting when they are doing their fires. And so this has been one that's been big in Nebraska, where I work, and really can limit the amount of time that they can burn, because almost everyone there is using federal cost share money to reduce the cedars on their landscape before they burn. So they have a cedar encroachment problem where they're trying to restore rangelands from cedar forests. And so they get cost share money to cut some of the cedars down to create fire breaks so that it's more safe, and then also to increase the intensity of their fires so that they can reverse some of this shift to cedar forest. And they do almost all of their burning in the spring, but at the beginning of every April, the Migratory Bird Treaty Act kicks into place, and then those landowners that are using cost share money have to have wildlife biologists out to the property before they do their burn, and if there are any nesting birds in the area, they are not allowed to burn once the nesting birds move in. And so this can really limit the amount of time that they're allowed to burn. And then there are a lot of different local and municipal restrictions that come into play in different areas. A lot of them are air quality related, and I'll talk about one of them here in a minute. Okay, and so just a little bit more on the forest fire control laws. They really are aimed to limit conditions under which prescribed fire can be conducted to maintain safety and avoid escapes. And this is important, but I think that they can limit a lot of conditions that need to be targeted for fuels reduction and really limit the amount of timing that can be done. So it's important to consider a trade-off between safety and actually getting the amount of prescribed burning need to reduce wildfire in the future. So if the goal of the forest fire control law is to disallow dangerous burns from happening, and that reduces your ability to reduce fuels and therefore creates a perfect opportunity for wildfires later, then it's undermining itself to some extent. So I think forest fire control laws can really limit the amount of fuels management that agencies are able to get done. And so this trade-off should be considered in thinking about forest fire control law. So a little bit about the state and national air quality laws. So they impact both burning extent and timing. The states implement plans under the Clean Air Act. They focus again on the control of particulate matter. So they're required by the Clean Air Act to have a certain level of attainment. And again, I'm not going to go into a lot of detail on this because there was a good webinar on it a few weeks ago, and it's recorded and online for you to watch if you're more interested in more information on air quality laws. But just to point out, they can shut down prescribed burning or limit the amount of prescribed burning when the areas come close to reaching Clean Air Act allowable particulate loads. So for instance, in the Flint Hills of Kansas, it's a large beef producing area. They do about 2.4 million acres a year of prescribed burning, and most of it's done in early spring because they've seen that as the safest time for them to implement prescribed fire, but also the most effective for achieving their management goals. And so a large swath of the Flint Hills of Kansas is burned every year. And then there are also additionally some wildfires that go through there. And over the years, air quality complaints have rolled in from as far away as Tennessee. And in Lincoln, they have air quality issues every year that they have the Flint Hill fires. And so we've really seen a lot of air quality containment issues happen here. And now they haven't been shut down ever. And that's mostly because when the complaints are registered, they're registered with the Kansas Department of Health. And there isn't really a single point source because it's many landowners all burning at once. And so they can't really attribute the air quality issues to any one individual burner. But there has been litigation, and most of it has not gone anywhere because they don't have a particular defendant that they can blame for the air quality problems. But it's something to keep an eye on because in many places where you have this kind of rural urban interplay between where the effects are being seen of the smoke and where the effects of the prescribed fire are benefiting people, this disconnect can really lead to issues. And so I think it's something that going down the road further, the Flint Hills is going to increasingly run into some trouble with getting their prescribed burns done as more and more cities and areas are litigating or trying to bring lawsuits. But for now, it hasn't shut down any prescribed burning in the Flint Hills. Oregon is another place where prescribed fires until recently, were shut down for smoke intrusions. So in Oregon, they have a much higher standard for air quality than in some of the other states. And so the states can enact more stringent air quality standards than the federal air quality standard. They just have to meet the limit of that air quality standard for federal. And then if they want to add more stringency on top of that, they can. And Oregon for a long time was one that did have a very stringent air quality standard. So in Oregon, the prescribed fires could be shut down for smoke intrusion if they increased the amount of smoke over the limit for even an hour during the day. In most places, it's over a 24-hour rolling period. And this is important because fire typically pushes the limits of air quality for just a short time and then drops off as the smoke settles and moves on. And so crafters of Oregon's new smoke rules knew this 1 hour limit was really limiting the amount of prescribed fire that could go on. And after a particularly heinous wildfire year, they decided to do this new smoke, or draft this new smoke bill. And so now they are allowing exemptions from the 1 hour rule for if cities and counties deem prescribed burning to be important, they can get an exemption for their county or city from the DEQ in Oregon if they have a plan in place to warn and protect people from the smoke. And so this has really increased the amount of prescribed fire that people in Oregon can get done. And then again, I talked about all of the environmental laws that can limit the amount of prescribed burning that's done. Again, prescribed burning can be limited in timing due to erosion. This is largely in Western states with steeper slopes where they limit burning a lot during drought to avoid for the potential movement of soil following fire. Because if the fire occurs, removes the vegetation, and then the rain comes after it, they can have a lot of sedimentation in that area. But this also limits their ability to target some of the conditions that they need, especially in areas that are facing woody brush encroachment into grasslands, like the Great Basin and the Great Plains. And so it's important to consider these trade-offs as well. We have erosion on the one hand, but then we have our ecosystems shifting to invaded or undesirable ecosystem types as a result of not being able to burn at the times that we need to achieve goals. And then also, again, I talked about the Migratory Bird Treaty Act, and then NEPA also has water and sedimentation requirements, and the National Forest Management Act has some sedimentation and water requirements as well. So this is just the output of a model that we did in a limited area in Nebraska. So it's really hard to collect the type of data you need to figure out how much reduction in burning is occurring as a result of these laws. So for a limited area in Nebraska, we collected information for a several year period of the amount of fire that was being conducted by private lands burners, private land managers. And then we looked at all of the different statutes, and given the burn days that were available to the managers, and then how many managers said they were affected by these statutes, we were able to model how much imposition in burning was done over time and space. And so the Nebraska open burning statute that I discussed at the beginning of the webinar, that was limiting a lot of burning in both time and space. And so a lot of people didn't get their burns in at all because the burning statute limited them all the time. And so spatially, there were counties that just weren't getting burns done because their fire chiefs weren't allowing the burn ban to be exempted for them. And then in time, because there would be periods of time during which the fire chiefs wouldn't allow burning, and then other periods of time when they would. And so this, if there were no restrictions based on fire chiefs deciding they didn't want to allow a permit, then we would see a 20% increase over time and a 15% increase over space in the amount of prescribed burning. And then also these forest fire protection laws and best management practices, we looked at agency prescribed burning because they mostly apply to agencies, and we could see that they were also limiting people in time and space from doing burning for similar reasons. Conditions determine when one can burn under the best management practices. And so the burn window was limited in time, and then some people weren't getting to burn at all. And so spatially burning was shut down. Air pollution emergencies were much less of an issue. We only had one instance of non-containment where a fire was shut down. That was affecting air quality in Colorado. And then the water quality BMPs applied on agency land as well. And we saw that they weren't imposing a huge reduction in burning for agency folks. And mostly that's a result of the flat topography. And so we were seeing in steeper areas of Nebraska where we would have issues with sedimentation, where the water quality was becoming an issue. Endangered Species Act was an issue for quite a few agency folks. They weren't allowed to burn because of endangered species. We have an endangered beetle in Nebraska and several other state listed species. and fires were being shut down entirely or for periods of time due to these different species. And then again, the Migratory Bird Treaty Act in Nebraska is a huge one because most people like to burn early spring, and that shuts down everyone with cost sharing from burning after April 1st mostly, unless they've been found not to have breeding birds at that point in time. And so that one was really limiting in time, not as much in space, although to some extent people weren't getting burns done so in an area, and so that was affecting the spatial distribution of burning on the landscape as well, but very small amount. Migratory Bird Treaty Act was mostly limiting the time that people could burn. So they were rushed to get all their burning done during one period of time, and they didn't get as many acres as they wanted to get. So wildfire has become increasingly difficult to manage, and a lot of the reason why the Right to Burn Acts and the different laws are in place is to prevent wildfires or limit the effects that they're having on people, property, and communities. It's over time becoming more and more difficult to manage because building in the WUI has put lives and homes in the paths of wildfire. Changing climates and fuel structures have increased the frequency and severity of fire across the US. We've seen papers from the Western US, and my lab just published one from the Great Plains showing the increase in wildfire risk over time as a result of some of these shifting fuel structures and climate characteristics. So prioritizing fuel reduction requires trade-offs. This environmental laws need to be carefully considered because they could be undermining their purpose for which they were intended. So the Endangered Species Act is meant to protect fish and birds, and that's very important. But if in the long term they're shutting down so much fire as a result of this that habitat is becoming altered and fire-dependent ecosystems are losing some of the characteristics of habitat that are important for these endangered species, we're going to have a long-term loss of the species, the very species these laws are meant to protect. So by focusing on the short term to the exclusion of the long term, some of these laws can be a little short-sighted. So I think there's opportunity for considering trade-offs and building some of these into the enforcement and implementation of some of the environmental laws that we see. And it's really important because otherwise, these laws are going to be counterproductive to achieving the very goals that they're set out to do. I just want to make a note that while most of my work focuses on prescribed fire and how different laws can reduce the amount of prescribed burning that goes on, other realms of fuel reduction, such as mechanical thinning, establishments of fuel breaks, that sort of thing, have also been hindered by environmental regulations. So of course, the environmental laws are very well intentioned, as are the safe burning laws and all of the best management practices. They're all intended to protect our wildlife, protect our waterways, protect our personal property, protect human life, and it's all very well intentioned. But they can have unintended consequences if provisions aren't made to consider these long-term effects and the trade-offs that exist. So with that, I just want to acknowledge all of my co-authors, especially my postdoctoral advisor, Drac Twidwell, and co-authors Urs Kreuter and William Rogers, all of the state forest service entities that helped me collect the data for the analysis of liability. Thank you very much. I know that was more work for them than they hoped to do, and they were all very helpful, and I appreciate it. And my funding sources from the USDA, Joint Fire Sciences, a private environmental research center, and the Nebraska Game and Parks Commission have all provided funding to support this work. And I will take any questions.
All right, well, thank you very much, Carissa, for the presentation. And let's go ahead. I'll pull up my slides here that have your email address so that if anybody has questions and they have to jump off the line real quick, they'll be able to take that down, make a note, and reach out to you in the future. So at this point, we do have time remaining this afternoon. for questions from the audience. So if you have questions for Dr. Wonkka, please go ahead and put them into the Q&A tool in Zoom. If you are looking for SAF CFE credit for your participation today, I have already put the link to provide your information in the chat window, and so you should be able to see that there. So make sure if you're interested in those CFE credits, you click on that link and provide your information. So we have a question that's already come in from Tom, and Tom says the Migratory Bird Treaty Act allows for broad prosecutorial discretion and is being used to allow burns even in nesting season where birds are dependent upon fire-based ecosystems. So, okay, he then follows up that question and says, is this discretion used in allowing or facilitating for burning?
So there's really a vast discrepancy in enforcement of the Migratory Bird Treaty Act from region to region, and it's been surprising. So I've seen the Migratory Bird Treaty Act be applied to shut down fire in fire-dependent grasslands in Nebraska, but in other places that's not the case at all. So I do think that it built into that law is the capacity to do as you say and allow for burning during breeding bird season with this long-term goal in mind and the larger implications of loss of habitat. But the issue in Nebraska has been that it's not been enforced that way. So I think there's a large discretion across the regions as to how it will be enforced in the different states. And it would be nice to see some national level guidance on how it should be enforced come down from above and help to move us toward this understanding that prescribed fire is necessary to help breeding birds in some ecosystems. So yes, I agree with you that that is built into that law, and there is real capacity there, and it comes down to how it's being enforced in the different regions.
And here's a question that came in from McCree in the chat window. And the question is there a roadmap or lessons learned document for states to follow to get their burn law statuses changed? That's a good question.
You know, I don't know that there is one at this time. I think that would be something that's a good idea to put together. Mm-hmm. I guess I try and show all the different state statutes in order for people to understand why it's important to have statutes worded in certain ways. And then also the ones that have really been effective can be roadmaps for how to draft that legislation. As far as working with people to get it, to get the statute adopted, that's been much more difficult. So in Texas, there was the Right to Burn Act proposed. The legislation was drafted. A senator was supporting it. It was modeled after the Florida Right to Burn Act, and then it just didn't gain the support of the prescribed burning community for some reason in that state. And there were particular individuals in the burning community that thought it might be a bad idea, and so they shut it down. So it would be nice to have a roadmap for moving forward, but honestly, I feel like for the most part, it needs to be in a lot of places that don't currently have Right to Burn Acts, needs to be grassroots approach. You need landowners to be excited about it and to come to an agreement on what would be the best way for them to burn, and other burners, so agencies, fire managers, you need groups to come together. And I think this is why the prescribed fire councils are really important, because they have all of the information usually about what the constituents of their group are interested in seeing happen in the state. They know if people are ready to push for legislation to be adopted. And then they can usually get the information from other prescribed fire councils, because there's also regional organizations and hopefully eventually a nationwide prescribed fire council that can share a lot of the information among states where we've had prescribed fire acts and then places where we haven't had them. So I think the prescribed fire councils and coalitions are really going to be a source for this roadmap I think going forward, for those to develop and get the information they need and gain membership, that is the first step in order to get a lot of support for prescribed burning legislation to be pushed through.
Based on your work, do you think that expanding, if you were to choose between the two, and that's a bit of an unfair thing to ask in a question, but I'm going to do it. If you had to choose between expanding gross negligence in the states that don't have that, or to increase right to burn acts, which do you think would be more effective in increasing the number of acres burned?
It's really hard to separate those two because most places that have prescribed burn acts do, or have gross negligence liability standards, have that embedded in their right to burn act. I think, though, having the right to burn act in place first paves the road. So if you have this language where the legislature has said fire is important to this state and these are the reasons we'd like to promote it there, then that paves the way for further down the road coming in and saying, well, we're not seeing prescribed fire happen the way that we would like it to from this statute. Can we add limited liability to it? And it's much easier then to add it in if you've already created the right to burn in the state and you know that this is an important component of land management in the state. And so I would say that that would be the first step for me if the two were separated. And a lot of places have tried to attach gross negligence liability, limited liability to their right to burn acts and had to take it out because it wouldn't go through legislature, but the right to burn act still went through. Tennessee is a good example of that. They initially had gross negligence for fire and smoke as a part of their right to burn act, and they couldn't get it to go through. They had unfortunate timing. They were legislating the right to burn act at exactly the time that a large escaped fire in Colorado resulted in huge loss of life and property, and some senators were just unwilling to overlook that, and they felt that gross negligence might increase the carelessness of prescribed fire application, and so they weren't able to get the gross negligence limited liability, but they still got the right to burn act to pass. They just had to put simple negligence in instead. So I do think that's the important first step, and then over time push can be made to get gross negligence and limited liability in as well.
Here's a question that came in. Someone asks, were cultural resources laws, either through NEPA or individual states, did you see them negatively impacting the use of prescribed fire?
So cultural resource laws are a little bit, I think, a little less impactful on prescribed fire on private lands, but they can affect agency prescribed fire because they need to be included in all of the environmental impacts. So there's environmental impacts and then also cultural resource impacts that need to be addressed by all agency burning. For private burners, it's less of an issue. But indeed, it can be limited in agencies due to cultural resources. That being said, if they have a plan for protecting the cultural resources within the prescribed burning area, they tend to be able to move forward with their prescribed fire.
And last question I think we'll take this afternoon. Tom has submitted and asked, can you discuss case law experiences across the South, which to me sounds like a pretty broad question.
You would think it would be, but the thing about case law is, unless it's appellate case law, it isn't readily available. So to find case law for an individual county, you would mostly have to go, so cases of first consideration, which means if someone's sued as a result of an escaped prescribed fire, they will go to a district court judge, a court of first instance, and they will take their case there. Most prescribed fire cases are settled, so we don't see a lot of them actually go to court. Therefore, there's not a lot of first impression cases to begin with. And then beyond that, it's very hard to get access to those cases unless you know that particular suit took place in that particular county and at least one of the names of the people involved. And then you would have to go to that county, to their online website, or some of them don't even have things archived electronically to get the transcripts for that case. So it's very hard to find prescribed fire cases unless you know exactly where one occurred and it hasn't been settled. So basically what we're limited to is looking at appellate case law. And appellate case law means that there was some error that the trial court made in adjudicating the case that's on appeal. So the defendant was found guilty and he's appealing because he thought there wasn't enough evidence to rise to the level of gross negligence, like the Carter v. Wolf case that I presented earlier. And so you might think that there would be a lot of that, but there really isn't. So the case law across the Southeast is limited to a handful of cases, and the descriptions of the cases are not always helpful because they are in the appellate court because of an issue of law. So a lot of times it'll be something completely unrelated to the actual content of the case that they're adjudicating, like standing to sue, or how a certain statute has been presented, or how the evidence in the case was presented, whether that was appropriate or not, or whether the argument was even legitimate. So actually finding statutory law issues in the appellate case law is difficult. So the Carter v. Wolf was the one that I saw that addressed the gross negligence standard specifically. That being said, I haven't been through the Southeastern case law in a few years, so there may be more now, and it's all accessible online, so you can find the appellate case law. But again, whether it's going to be that helpful is questionable, because a lot of them are issues of law that don't actually address how the judge is interpreting statutes. That's mostly in cases of first instance, and those are inaccessible unless you actually know where it happened and who was involved. So I'm sorry, that's not a very helpful answer, but case law is tough to find.
I think it was a helpful answer. So it looks like we have run up to the end of our time allotment today. This has been fascinating. Thank you so much, Dr. Wonkka, for your presentation. Thank you everyone for joining us today, and have a great afternoon.